Welcome to the Roberts Law Office Injury Podcast. Kentucky attorney Jeff Roberts has over 25 years of experience. He'll provide answers to your questions related to personal injury and automobile accidents, workers' compensation claims, and Social Security disability benefits. Let's join Jeff for this episode. And friends, welcome back. We are in Calloway County with injury attorney Jeff Roberts. Jeff, how are you today?
I'm doing good, Jim. How are you?
I'm always good, man. Good to see you again. And today we're going to kind of focus in on the games that the insurance company and their attorneys can play after a serious or catastrophic trucking accident. And this is something with your past 33 years now of experience that you've unfortunately seen quite a bit of because you handle a lot of truck cases, car wreck cases, motorcycle accidents, things like that. So let's jump right in because this is something that I think is going to shock a lot of people because typically we think, well, I've got insurance, I'm going to be okay, and, we'll see what happens. But nobody plans for this. And then when the other company really starts playing games, problems arise.
True. Nobody plans for to be involved in a motor vehicle crash at all. It's always something that occurs unexpectedly from that standpoint. And a lot of times people think, well, if I'm in a crash with a semi, then, they're going to have good insurance. Everything's going to be fine from that standpoint. First thing is, as we mentioned before, whenever you are involved with a crash with a semi, a lot of times the injuries are much more significant because of the weight disparity of the vehicles, how heavy the semis are compared to a passenger vehicle. And, passenger vehicles, they have are making them better and better and more crash worthy in a lot of respects. But you got extremely heavy vehicle crashing into them at highway speeds at times, the injuries can be catastrophic and can be very, very serious in those situations. And what can occur in those, especially the larger trucking companies and the bigger insurers, one of the things that I have found in regard to suing trucking companies, but also on my side of being on workers' comp, representing truck drivers when they weren't at fault in causing the wreck and they were injured on the job, and then I represent them. One of the policies that most trucking companies seem to have, at least from my experience, is that the driver is to immediately call dispatch, call the company, and let them know about the wreck. Frankly, I've had some drivers tell me I'm supposed to call the company before I even call 911 if I'm involved in a wreck or involved in a collision of any sort.
And why would they do that?
The reason they do that is because these companies have a rapid response team for these collisions. They have accident reconstructionists that will show up and other experts potentially, depending on what type of collision. If it's a very severe collision and they know there's going to be serious injuries from it, they're going to have accident reconstructionists. They will have possibly expert witnesses that can measure crash data and things of that nature. That they get out to the scene, that very well may bring, the accident reconstructions will most certainly have the ability to take photos and measurements, but very well may bring drones out so that they can do aerial photos or aerial pictures of the scene that are taken while the vehicles are there. I mean, they get people to the scene very quickly. They've got a lot of these companies have rapid response teams that are based in regional areas throughout the country so that they get the call that there's a crash. They reached out to that rapid response team and they start going to the scene as quickly as possible.
And I tell you, it's not that they're there to render aid like a first responder. They're there to protect liability.
That's it. They're there to, at least in my experience, what I think they're there to do is to, if there's anything that lessens the culpability of the trucking company, you can be rest assured that's going to be photographed, that's going to be documented very, very thoroughly. If there is something that, if there's a area that shows that the trucking company, the truck driver, uh, did not brake at all. There's no skid marks or nothing to indicate any braking of the truck driver. Well, the aerial photograph they take will end at the back of the truck. It won't show the road back behind it that shows there is no skid marks or any kind of braking from the truck driver or things like that. You can document things in a way that you leave things out intentionally without it looking like you're leaving things out intentionally from that. And you'll see that occur. And if they've got some evidence that if they get there very quickly, they get some evidence that they think helps their case that they weren't at fault. I have seen situations where they've shared information with the investigating police force from that standpoint, and it's shown up in records. Now, the police report said this information was provided by and indicated who it was. And I can't remember if it said independently or not independently verified, or we don't. I can't remember exactly. It's been several years ago since that happened, but so you can see that situation where they get the people there to start documenting things that are favorable to them from that standpoint, and most of the time the injured party in these wrecks is so severely injured that the police officer doesn't get a chance to talk to them because of their medical condition. They're going to the hospital immediately. Sometimes in Western Kentucky, especially, you see them being life-flighted to another hospital out of state from that. So it may be days or longer before the police are able to speak with the actual victim.
And that assumes it's not a traffic fatality.
Assuming it's not a traffic fatality from that standpoint. So those are, it can be a long time before they actually are able to interview them, and they may have to do it over the phone type setting. But depending on the severity of the injury, it could be quite a while before there is any input, if at all, from the victim in this situation from there. And that's part of the reason why you need to get an attorney involved very early in the process so that you're someone that's looking out for your interest can get an accident reconstructionist out to the scene before skid marks are or have faded away, or there's been lots of rain that have made them less, or there may have been another crash and it's hard to tell whose marks are whose, and that's what you'll see argued. Well, you weren't out there at the scene. You don't know if these skid marks were made from this wreck or for a wreck prior or a wreck since. Same with gouge marks and things of that nature in the pavement that accident reconstruction is used to locate vehicles, etc. So the quicker that your side can get an accident reconstructionist out to document everything, the better off you are. And it also helps when you get what will occur at times is evidence will be lost or destroyed. Now, you can debate over whether some of this is intentional or not, but if you have a truck that is severely damaged and clearly totaled, well, the trucking company could have that, or insurance company could get that to a scrapyard and have it destroyed before black box data is pulled off of that truck to see what speed that truck was going. Was there braking, things of that nature that you can get from that black box. My understanding from talking with expert witnesses, accident reconstructionists, are that in vehicles that aren't totaled like that, it can first off be repaired, so you can't see where the damage is and get it in, get it repaired before you get a chance to go photograph it. And also, the way the black box is, as I understand it, is if you turn that key on, enough times, it eventually will. It cycles it through, and it can cause the black box to lose data from the crash as well.
It's almost like recording over an old VCR tape or something like that, right?
To some extent, exactly. When you have, the black box records for a period of time from a crash, but when it cycles back through over enough times, and it basically starts rewriting just like a hard drive on a computer does to some extent. It override other files. And my understanding is that's what occurs now on these devices. So you've got those things that evidence can be lost.
Accidentally on purpose.
Yes. And, in Kentucky, where I practice at, there is, even if you can prove it was destroyed intentionally to some extent, all you get in Kentucky is a jury instruction that tells the jury you can infer the fact that they destroyed this means this would have been favorable to the other side. That's all you get is that the jury can, if they wish to do so. They may infer if they want to do so. They don't have to, and the insurance companies are going to go in there and say, well, we didn't. We had no ill intent in getting the truck repaired. We wanted to get it back on the road so it could start making money again. The driver could start feeding his family again. We weren't trying to destroy the evidence. The same with the black box data. We recycled it because we were looking at it, investigating things, or repairing it, etc. And, if it is a vehicle that has dash cam, well, we only keep the dash cam videos for 2 weeks. Nobody told us they wanted this, so part of our normal practice was to destroy that. And you have those type of arguments, and so the jury may not, even though clearly the insurance company knew there was going to be a car or a lawsuit over this because of the severity of the injuries, they will argue, well, the jury should not infer that this would have helped the plaintiff. We looked at it. We don't remember it showing anything that helps the plaintiff's case type thing. And so that's in Kentucky, I think Kentucky should be much stronger in regard to how destruction of evidence is handled, whether it's accidental or intentional destruction of evidence. And in Kentucky, whenever I get involved in the case, one of the things I do is I send a preservation letter out. Don't destroy any documents. Don't destroy any data. Don't change don't repair anything or until we have a chance to inspect it, to download the black box, etc. And so once they get that preservation letter, then if they destroy it, much easier to get a jury to say, yeah, you destroyed this intentionally because it was going to be helpful to the plaintiff. So getting an attorney involved who handles these cases frequently, like I do, that can get that preservation letter faxed over right off the bat to make sure all of this stuff is preserved so that we can all know what the facts are, what really happened, and not only me and my client, but the trucking company, the insurance company, and the jury, if it goes to a jury, can know who was at fault and make the proper determination on the facts as to who was at fault in causing the collision.
Well, Jeff, as we were talking about the kind of the outline for this episode, you brought up another case or another situation that I never even thought about, but it was the intentional misclassification of drivers. How does that come into play?
Frequently, I have seen trucking companies try to classify the drivers as independent contractors. I've seen that frequently, both in representing individuals injured in car wreck crashes with trucks, semis, and in workers' comp thing, not wanting to cover the drivers as employees, claiming they're independent contractors. And some companies will do kind of a lease to own type thing on the truck, and so you're purchasing the truck and you're the independent contractor. We're hiring you as an independent contractor, even though they're providing the truck. They're getting all the loads. You can only drive for them, et cetera. Everything of an employment relationship is there except what's on paper.
They're trying to walk that fine line that limits, again, their liability.
Exactly, to try to shift it to the truck driver as being responsible and not the trucking company from that standpoint. And there are some independent truck drivers out there but the independent truck drivers, as a general rule, get their own loads, and they can go to any. If you're a true independent contractor, you can drive for this company one day, and after that load's over with, you can drive for another company the next day and take loads all over and
You're
pick
free
and choose.
agent. Yeah,
Pick and choose what you want to do, and you don't have somebody else getting your loads for you type situation. That's more of a true independent contractor setting. I've got some friends actually that are that way. They own their own semis as part of their farm operation, and then during the wintertime, they will use those semis and drive for other companies to make money through the wintertime, which is perfectly valid to do and frankly smart to do in that regard if you've got that and that's what you want to do. But if you're only a truck driver and you only drive for this company all the time, but they try to classify you as that, then usually that's done to avoid a lot of insurance requirements that are there from that standpoint. And I do see that occur. And you'll see some of these companies will, they kind of tried to hide the ball type situation where they use certain shell companies. One company will own the truck, but then they'll lease it to their subsidiary, and then trying to figure out who actually employs that, and then somebody else employs the driver type situation, and you've got to maneuver through and find out who all that is, and the police report's going to say, well, the vehicle's owned by this company here, and then you find out, well, yeah, but we own the truck, but we leased that truck to XYZ Trucking Company, and XYZ Trucking Company is the one responsible. And then you go to XYZ and say the driver was employee of this temp service type thing, and so they're responsible for their driver's negligence, not us type situations. And then you've got the loaders. Could be that's one other thing they'll claim was a load shift type situation, and we didn't load the truck. So there's a lot of moving parts that get involved in these type of crashes that you have to get on, and sometimes if the attorney is contacted late in the game, trying to figure out all the parties and who all they are can be very difficult. And if you're getting close to the statute of limitations, and a statute of limitation, I know I've mentioned it before, but if anybody's listening that doesn't know what that is, the statute of limitations is the law that says you've got a certain time frame within which to file that lawsuit within, and if you don't file it within that time frame, then you may be forever barred from pursuing that claim. And so if you're getting close to that statute of limitations, and the only people I know of, you come to me a month before the statute's expired, police report says the truck was owned by XYZ Corporation, so I sue XYZ Corporation. We get into litigation and then find out that XYZ Corporation, while they owned the truck, they leased it to this other company and had leased it for a long period of time. And the lease said they weren't responsible for it, and the leasing company is. And so there's a major party there that we don't have sued, and the deadline to sue them may have already passed by the time we get that information.
Because you have to specifically name those parties. You can't just say, we're suing everybody. You've got to be specific.
You got to be specific. Yeah, you can't just say, I'm suing everybody. I'm suing XYZ Company and anybody else involved in this owning or leasing or doing this truck. It's got to be XYZ Company, ABC Company, and you've got to specifically identify. And after the fact, I could go back in and amend a complaint to add new counts, new issues against named defendants. But after the statute of limitations is run, you cannot I don't think you can successfully amend the complaint to bring in a completely new defendant. They're going to argue your deadline's passed, you're too late to bring us in at this point in time.
And friends, Jeff, if I could,
Go ahead.
we actually did a full episode on understanding your statute of limitations and how that can affect your case. That's back in episode 55, which you can find on Jeff's website, jeffrobertslaw.com. You can find it on other podcast directories. But if you just want to go back to the website, go into podcast, look for episode 55, and that's where we spent probably a good 30 minutes talking about that topic in particular.
Yeah.
Yeah.
Yeah, so that's something that another reason you want to get an attorney involved sooner rather than later in regard to these. And another aspect to these is as far as the preservation aspect of it, one thing I didn't mention is you need to make sure you're preserving all the data on that driver. They should have a driver file. They should have a driver file on him before they even hire the individual from that perspective. There should be a driver qualification file that you can get access to. And making sure they preserve that, because if it is a driver who has a history of bad problems, he may not be a driver with that company after this severe wrecking. And that's what we got rid of that file because we got rid of him. So you want to preserve those things. They're supposed to keep those for a period of time afterwards anyway, but still want to make sure you're preserving that and getting that information from them from there. And then, like in a lot of car accident cases, car crash cases, they will blame the victim. And you'll see that they'll try to blame the accident either in whole or in part on the victim's actions. From there, if they'll try to claim that the victim may have been the one that crossed the center line, for instance, or the victim was driving too fast for the road conditions or speeding or something of that nature, sometimes without having any evidence whatsoever of it, a lot of times without having any evidence whatsoever of that from that standpoint. So getting involved in getting the black box data, the event data recorder, commonly referred to as black box, but getting the black box data off of your client's vehicle is important, and you want to get that before the vehicle is repaired or is sold for scrap and you can't track it down anymore if it's total loss. And so, and frequently after these collisions, the owner of the vehicle that is severely damaged, and a lot of times they're totaled in this, and they need to get that total damage, the payment for that property damage so that they can go get another vehicle to be able to get back and forth. So they'll sell it to the insurance company. The insurance company will then sell it to Copar or something like that, and the vehicle be destroyed or scrapped or whatever, and we can't get to the event data recorder for it anymore in that regard.
But the other factor was shifting the blame a little bit. You said even if it's in part, Kentucky, as you've stated back in episode 96, we did a full episode on this, where you discussed pure comparative fault in Kentucky. Do you want to talk about that just briefly?
Yeah, in Kentucky is a pure comparative fault state. What that means is that if you are involved in a collision, then the jury can apportion fault to a variety of parties in that, the named parties or settling non-parties, so that they can apportion fault to the defendant, they can apportion fault to the plaintiff, and if there was a third party involved that settled out, they could apportion fault to that third party. From that standpoint, so they could say 1/3 each, or 20% on one, 20% on another, and 60% on the settling party or something from that standpoint. And if that's the case, that if the defendant is found to be 25% at fault, then they pay 25% of the damages. If you're found to be 25% at fault for causing the wreck, you do not receive that 25% of your damages because you were at that much at fault in causing. So the defendant pays for whatever percentage of fault that they caused in the wreck. So
if that truck driver insurance attorney can in some way say, hey, look, jury, you gotta take this into consideration, and they can shift that blame, again, that's limiting the amount of money they're going to have to pay. So that's limiting that liability,
Correct.
which is, again, comes back to the reason they're trying to play games with this, or
Correct.
at least sow a little bit of doubt in their mind, right?
Yes, exactly. And they'll get involved. One of the things they do too is, early on, they will try to get a recorded statement from the driver, the other driver from that standpoint. And they've got, it may be an insurance adjuster or claims representative taking the recorded statement instead of an attorney, but it's someone who is trained and knows how to ask the questions and knows what questions to ask to kind of shade things the way they want it to be, and then it can come back against you later on.
But they were so nice.
Yes, they were nice. And they will be. They'll be very nice in that recorded statement from that standpoint. And, as a general rule, I'm not completely opposed to a recorded statement of my clients. I prepare my client ahead of time. I'm listening in. And I'm with the understanding that I get to ask questions as well on the recorded statement. But normally what occurs when I'm involved in the case and they reach out and want to do a recorded statement of my client, my response is, sure, we will schedule that. And when we finish taking that on the same day, right after you finish taking my client's recorded statement, I want to take a recorded statement from your insured, the driver of the semi or the driver of the other vehicle. And amazingly, they no longer need a recorded statement of my client in that situation.
Just kind of works out that way.
Yeah, because they don't want to put their client up for, or their insured up for a recorded statement either from that standpoint. And then they'll start diminishing the damages like you see in all car wreck cases as well. They will try to say, well, he had pre-existing problem, he or she had pre-existing problems, or they're not as injured as they claim they are. They're just claiming this is part of this, and there's no true proof or objective evidence to show that that was injured type thing. So you'll see them do that where they're trying to shift fault off on the plaintiff and then also lessen the injuries that the plaintiff has in that. Frequently, in that context, they will hire a doctor to do an examination of the plaintiff to say that the plaintiff's injury is not as injured as bad as the treating doctor usually indicates that they are injured in these type of situations. So,
and again, that's just minimizing the extent of the injuries, which again means I have to pay out less as the insurance company to, even though we were at fault, it was something else that was going on.
Correct. And in my opinion, some may disagree with me in this regard, but part of the whole process at this from the get-go when they get notified of the crash is to lessen their exposure.
Yeah. I mean, it's a business. That's why the insurance companies have such beautiful large buildings, is because whatever they don't pay out, they get to keep.
Correct.
That makes a lot of sense. There was also the issue out there of possibly claiming there was a phantom vehicle.
Yes, that occurs. You'll see that when these collisions occur. A lot of times, you'll see the driver of the truck say, "Well, this other, I swerved because this other car had pulled out. That was, nowhere to be found. It drove off. It wasn't involved in the collision. It just swerved, so I had to swerve, and that's what caused me to hit this." This car that was coming up on the left-hand side. I was driving on the right-hand side, slow lane car coming in from the on-ramp, and they didn't pay attention, or they didn't speed up to get in front or let me go. They were merging in, and they caused me to have to swerve over into the other lane suddenly or something of that nature.
And of course, it happened so quickly, I didn't get I can't remember the make and model of their car, and I didn't get their license plate or the state of the license plate.
I didn't get the license plate, didn't get anything. They didn't stop. Nobody else saw this phantom vehicle, but you will see that being claimed in these cases that there's some other cause that is impossible to prove because the only person who saw it is the semi-driver at times.
Right,
Yeah.
right.
Or and you see that even in car. Yeah, it's not. I'm not trying to say semi-drivers lie about these things. I see that in other car wreck cases as well, from that standpoint, where the at-fault driver claims. Excuse me, at-fault driver claims that they that something else caused them to do what they did. So,
Hey, Jeff, just a minute ago, you had mentioned something about a pre-existing condition. They're going to say, well, the extent of your injuries are bad, but you already had that. So again, I shouldn't be responsible for all of it. Back in episode 30, we actually had a very extensive conversation on pre-existing, which applies both to workers' comp, but also to accidents and injuries. So
correct.
again, if you're interested in knowing how that plays out, check out episode 30.
Yes.
Jeff, as we get ready to wrap up, there's also the rush by the insurance company and their attorneys to try to secure a quick settlement. Do you want to kind of get into that and explain why that may not be in your best interest?
Yes, you'll see that at times they will try to offer a very quick settlement in the case, saying things that they're going to do things that you may think is good, but the law requires to start with. Like they'll say, well, we'll pay up to $10,000 of your medical bills. Well, Kentucky law has a provision in it called the no fault or personal injury protection, basic reparations. I've talked about it multiple times here. That says the vehicle you're in a collision pays up to $10,000 of your lost wages and or medical bills, and then the at-fault driver's insurance has to reimburse your insurance. So Kentucky law says they've got to pay that. If they're the at-fault driver, they've got to reimburse your insurance that money at a later point. So they're really not offering you anything when they say they're going to pay up to $10,000 of your medical. Kentucky law says your insurance pays that and gets reimbursed for that.
They were going to have to do it anyway.
Yeah, so we'll pay up to $10,000 medical, and because we're so nice and we're sorry that this happened to you, we're going to give you another $2,000 or another $3,000 on top of that to settle this case. And, frankly, there may be some situations where, okay, that might be what the case is worth, to be honest with you, but with a semi involved, it's doubtful that's going to be all that the case is worth, because the injuries usually are much more severe in those situations. And but they know if they can get in and offer you a real quick lowball settlement when you're out of work and you may not have any money coming in. You see these bills, medical bills coming in that you don't realize how they're going to get paid. Then that can, some people can say, they're going to pay my medical bills up to this dollar figure, and they're going to give me some money now, and I'll be able to make my house payment. I'll be able to pay my electric bill with this month, and all of those things, not realizing that now you've released that claim completely at that point in time, and your damages may be way greater, exponentially greater than what they offered you from that standpoint. And I think we discussed this in a previous episode about subrogation rights of health insurance companies. Well, if you settle that claim and then your health insurance goes in, the $10,000 is paid by your car insurance, they get reimbursed. Then they paid you another $3,000 on top of that. Well, then you incur another $4,000 of medical that your health insurance pays. Guess what? Now you owe your health insurance back that $3,000 that you recovered, and that's going to come out of you, not out of the trucking insurance company's pocket, because you settled and released that claim. And when you've settled that claim, part of that settlement is you're the one who's responsible for indemnifying and reimbursing anybody else who may have a claim to these funds. So by doing that, you can end up first off, you're giving up your claim for probably a lot less than it's worth, and you could be even putting yourself in a worse position by doing that than if you hadn't even settled the case, period. If you're concerned about it, they make a quick settlement offer to you, and you're not sure, call my office up, and we'll be happy to talk with you from that standpoint.
And Jeff, you've got two offices. Your primary office is right here in Calloway County, right here on Main Street in Murray.
Correct.
But you've also got another office up in Christian County in Hopkinsville,
Yes.
right there on South Virginia Street.
South Virginia Street and Virginia Place on South Virginia Street. I've got an office up there that is a by appointment only office. But I do have that office there that I meet with my clients up in that area, and it's worked out very well from that standpoint. Now, I have one phone number that I use. I also have an 800 number if people want to use 800 instead of the other. But the office number is 270-753-0053. If you want to do it toll free, you can call 1-800-844-5108. And you can call in and talk with me if you've been involved in a car collision, serious collision with a semi, and you want to talk about that. Call me up and we'll try to sit down and talk about your case. I prefer to meet clients in person if we can. If we can't, we'll talk over the phone or by video conference. From that standpoint, you know, as we've mentioned before, the way I work here in my office, I try to treat my clients well. One of the reasons for that satellite office in Hopkinsville is to provide service to my clients. We have a motto here at my office to provide small town service and deliver big city results, and we try to live up to that in every case that we handle from that standpoint. So if you're wanting a law firm that's going to keep you up to date and provide that individual service and not be treated like you're just a number to them, that we don't do that with our clients. And so if that's what you're looking for, give us a call and we'll see what we can do for you.
Outstanding. And Jeff, even though you've got the two offices here in the Western Kentucky area, you're not limited to Western Kentucky. I mean, you've got 33 years of experience, and you've probably handled cases all across the Commonwealth, I would think.
I have handled cases in a variety, all across the Commonwealth. I've handled cases up. You know, I have several cases right now in the Bowling Green area, in the Louisville area. I've handled them in Lexington, northern Kentucky, even eastern Kentucky. I've handled cases over there as well. Occasionally, as you know, with my practice, I'm familiar with a lot of other attorneys in the state, and you know, I get calls from other attorneys asking me to associate with them on certain cases. It may be a case over in eastern Kentucky, but the attorney is familiar with me and asked me to become involved and work with them on that case. And even cases out of state. You know, I've got one. Well, case you and I were talking about earlier, where it occurred over in eastern Kentucky, and it was an out-of-state attorney that had the case because the client lived in out-of-state, and he reached out to someone, and they told him to call me, and he and I have been associated on that case now for a little while, and are in the process of finalizing it at this point. But so I handle cases all over Kentucky. Yes.
Outstanding. Jeff, it's been a pleasure. I mean, you've got such a wealth of knowledge on trucking accidents just because, one, of the type of practice you've had, the number of years you've done this, but also your involvement with other trial attorneys across the state. I mean, you're seeing a lot of very interesting cases and actually pulling in some pretty good results. So, congratulations on that. Well, buddy, I tell you what, we'll be back in a couple of weeks. Thanks for your time.
Thank you.
Take care. Bye-bye.
Bye.
Thank you for listening to the Roberts Law Office Injury Podcast. Jeff will return in 2 weeks. Until then, he invites you to visit jeffrobertslaw.com and follow his firm on Facebook. At the Roberts Law Office, you'll find a history of small town service and big city results.